Good afternoon, everybody. This is your neighborhood state representative and a Merlin Law Group attorney, Sean Shaw. How's it going? It is good to be done with the legislative session. We ended Monday, and so I got back in town Tuesday and came into the office. And last Monday we were done. Sorry, and came into the office and blew the dust off my desk because I hadn't been there in a while because I'd been in Tallahassee, and got back to work here representing your clients here at the Merlin Law Group. I want to talk about a few things that happened up in Tallahassee during session. And of course, if you have any questions, go ahead and type them there in the area, and I'll be happy to answer them to the extent that I can. First, let me talk about the committees that I'm on. And the committee process is really where all the heavy lifting is done in the legislative session. You know, when a bill is first presented, or if we're talking about an idea that may turn into a bill, it is done at the committee level. By the time something gets to the floor of either the House or the Senate, it really should have already been vetted. The framework should already have been established. So the committee process is really where a lot of things are done. So the committees that I'm on are banking and insurance, civil justice, commerce, utilities and banking, and government operations and technology. And so the three I want to talk about that are important, probably important to where you're concerned, are commerce, banking and insurance, and civil justice. So any insurance bill, any bill that relates to the way that the law is practiced in our field, any bill that relates to the regulation of public adjusters, any bill that concerns insurance at all, I'm going to see a minimum of twice. So that's really good news. I'm glad I'm on these committees. I'm glad that I was allowed to be on committees that are really in my wheelhouse and in my area of expertise. So it's really a blessing that I was able to be on those committees and see a lot of these things up front. Let's talk about maybe some things that did not pass this session. PIP, personal injury protection, as we all know, is the way we do auto insurance here in the state of Florida. It's a system that, in my opinion, has outlived its usefulness, and I think we're really on our way to turning towards a mandatory bodily injury type system, at-fault system here in Florida. And without getting into specifics, that bill passed through the committee process, but ultimately it actually passed off the floor of the House, but it didn't pass the floor of the Senate. I think next year we're going to try to attack that again, and hopefully we can move to a mandatory bodily injury system as opposed to the current system we have, that is PIP. Assignment of benefits. This was an issue that came up we all know what assignment of benefits is. I've been on the record as saying I believe that there are some extreme abuses going on in the AOB context. I believe that we need change. I believe that we need stronger regulation in this area, and hopefully we're going to get there next session. In the assignment of benefits arena, there was a bill that came up in, I think, the Civil Justice Committee. And the bill had a lot of great things in it. It regulated contractors. It protected consumers, I thought, from some of the abuses. But it changed the ways that attorney's fees are done and handled in the AOB context. And if you know me, you know that I don't believe that the fix to any insurance problem is to change the way we deal with attorney's fees. The insurance industry loves to blame attorney's fees for any problem they have. Sinkholes, water losses, insurance fraud, everything is because of trial lawyers and public adjusters. And of course, you know me well enough to know I don't believe that. Although I do believe there are some bad actors in the AOB context, we ought to be going after the bad actors and not tinkering with attorney's fees. So I ultimately voted against that AOB bill in committee. Although it contained a lot of good things for the consumer, it changed the way we dealt with attorney's fees. And so I voted against it. That bill ultimately, I think, was temporarily postponed. It did not make it any further along in the process. The sponsor of the bill later on presented a new bill to the Commerce Committee that was really a lot closer to where I thought we ought to be. I was very close to supporting that bill, but again, it tinkered with the attorney's fees provision. Although it tinkered with it less than the first bill I saw, it still tinkered with it. And philosophically, I'm tired of making changes to the attorney fee statute because insurance companies claim that that's the problem. And in fact, in law, we already have a way to deal with this. It's called the Proposal for Settlement statute. which if you're a lawyer, you know that defense lawyers shove that down your throat all the time. So there's a way to protect the insurance company, way for them to protect themselves if they want to stop some of these, quote, frivolous lawsuits, unquote, which I don't agree with that term, but there are provisions of law that already exist. So I say all that to say, next session, if there's an assignment of benefits bill that has all the consumer protections and doesn't tinker with attorney's fees, I'm going to be prepared to support it. Regulation of contractors, time limits on the AOB when it can be revoked. You know, how quickly you have to let the insurance company come in and look. How many EUOs, or the ability of the insurance company to conduct an EUO of the contractor who performed the work. There's some things in there that I think, quite frankly, ought to be in there. And that might sound strange coming from me, given that I work here and given that I represent plaintiffs against their insurance companies in first-party lawsuits. But the problem is I have these cases and they come in my office and I'm incensed at this posture of the case and what has happened and what hasn't happened. And these potential clients that come into my office have been victimized. And really, I want to put a stop to that. So, and I think that next session, we're going to be able to pass something on the assignment of benefits issue. House Bill 912, or I think it is 911 actually, but it deals with insurance adjusters. And quite frankly, I'm proud of the fact that I was able to get 2 bills to the governor's desk as a freshman Democrat. This bill and another one dealing with affordable housing. It is extremely difficult to get a bill even to the floor of the House of Representatives. So I was able to get 2 bills, not only through the floor of the House and through all the committees, but we got a Senate sponsor who did the same thing, and we were able to do that. And Will's reminded me here, if you want to ask questions, there's a box down there for you to type in your questions, and we'll be happy to answer them to the extent we can. Those 2 bills, we were able, waiting on the governor to sign them. All indications are that he will sign them. So House Bill 911 regarding insurance adjusters, I'm going to talk about this more at FAPIA, but I had a blog on April 28th that the reason I wanted to get it out there is I was hearing some feedback that people were kind of weren't understanding exactly what the impetus of the bill was. So I'm going to talk about it a little more at FAPIA. The staff analysis for the bill is attached to the blog on the Merlin Law Group blog. April 28, 2017 is when the blog was published. I encourage anyone who has a question about what the bill actually does to go to that blog and pull up the staff analysis. In short, we are trying to eliminate the practice of unlicensed adjusting. That's what the bill aims to do. So all of these unlicensed entities that are adjusting claims, that are participating in the claims process, that is what we were trying to put a stop to. And when I say we, this isn't just a Shawn Shaw bill. This is a bill that was done in conjunction with the Department of Financial Services, with the governor's office, with FAPIA, with various former presidents of FAPIA, and myself. So this was a collaborative effort. A lot of work went into this bill, and that's one of the reasons that it got to the governor's desk. This was a collaborative effort and something that everybody was comfortable with. The point that we were trying to get to is to stop this unlicensed adjusting. So the bill does a few things, but the main thing, expressly prohibit unlicensed public adjusting that is done directly or indirectly. I know that you all hate that. You all don't want to compete with unlicensed people showing up at these consumer homes when you have to go through all the licensing, all the CLEs, and we have runners for other law firms, or we have unlicensed adjusters doing this work. That's not right, and we need to stop that. It deletes the provision of law relating to contracting policyholders, which was held unconstitutional. I believe this is the 24-hour provision that was held unconstitutional. That's no longer really a relevant part of law. This takes it out of law. It excludes deductibles from the calculation of adjuster's fee, and it reduces the time a PA apprentice must be supervised before becoming eligible for licensure as a PA. And so there were a lot of kind of loose ends in law that weren't really applicable, that weren't being used. We took a lot of those out, but these are the main 4 things that the bill does. Again, I'll talk about it more at FAPIA. If you have a specific question, of course, you can ask me in this little box here during the webinar. But this was an area that we really needed to attack, and I'm proud of the fact that I believe this is going to be signed into law by the governor, and we can put a stop to some of this. And quite frankly, uh, there's unlicensed adjusting activity not only on representing policyholders, but on the insurance company side too. I just want to make that clear. This is not just attacking and not just picking on public adjusters and those of us representing policyholders. I have gotten a lot of feedback suggesting that this is a problem going on the other side too. We're going to put a stop to it. And I do want to give a plug to the FAPIA convention, which is coming up this weekend, right, Will? It is this weekend, so I'm going to be in Hawks Cay on Saturday night is when I get in, and I'm going to be participating in the fishing tournament. And whether I win or lose, I'll be fishing, so it's going to be a good day no matter what. So we'll be fishing on Sunday morning. Then I think there's a fish fry later on that day, and then Monday I think I'll do the legislative update to FAPIA around 1:30, 1:20. But I will be at the FAPIA convention until I think Wednesday. So Saturday night through Wednesday, I'll be there. I look forward to talking to everybody. I miss a lot of my friends, but I will see you while we're there. And of course, if you want to come talk to me about any of these items or anything else, I will likely be at the closest bar in Hawks Cay, so you can come find me. I also want to let everybody know, you probably know that we're going to have a new chief financial officer here soon. So that is very important to everybody that's on this webinar, everybody within the sound of my voice. Jeff Atwater, I thought, done a pretty good job as chief financial officer. That's a very difficult job. It's a lot of balancing you have to do through. It's about consumer protection. It's about protecting the ability for insurance companies to charge the premiums. It's a lot of different entities that are regulated by the CFO, and I thought Jeff Atwater did a good job in that role. He has indicated that he's going to leave that job after the budget is completed here, and I don't actually know when the budget's going to be completed because there may be vetoes involved. We passed the budget last Monday, but I do not know if we're going to be called up to Tallahassee. I'm getting indications that we may, so we'll see. But when the budget's done, CFO Atwater is going to leave, and the governor will have the ability to appoint a new CFO. So the governor will appoint it, and then in 2018 there will be an election for the new CFO. So the governor's going to appoint one to serve for a few years, and then in 2018 we're going to have an election. I got some questions here. We'll get to those. So I just want everybody to know to make sure, especially those of you that are in FAPIA or in leadership at FAPIA, make sure that whoever the new CFO is, as soon as possible, establish that relationship so that he knows the good things that public adjusters do, so that he knows the protections that they provide to consumers, and so he doesn't believe the horror stories that I'm sure the industry is going to try to hit he or she with when they are appointed. And lastly, next session, one of the things I'm going to attack, in addition to trying to make sure we get this AOB legislation over the finish line, is the amount of money we pay in salaries to the guarantee funds, the people that run them, and citizens. If you've been reading the newspapers or you've been on my social media, you've seen me link to various articles that talk about how much money the executives make at Citizens, how much money they make at FIGA, how much money they make at these other guarantee funds, while we've seen no rate reduction, no premium reduction here in the state of Florida in a lot of years. And of course, every time you talk to anybody in the industry, it's trial lawyers, it's public adjusters, it's fraud. There's all kinds of reasons why premiums are high. Yet, all these guarantee funds that pay these executives through your premium dollars, all of them make a lot of money to manage not a lot of claims. Now, in the case of Citizens, of course, they are the largest insurance company in the state of Florida, so I can somewhat understand that they may be paying a little bit more than the other guarantee funds. But there's just several articles I've seen on Citizens and the way they conduct business, and it just seems a little too cozy, and it seems just, it looks bad. And if it smells bad and it looks bad, it's probably bad. So next session, we're certainly going to try to make some public, well, actually now we're going to try to make some public records requests here coming up soon so we can get to the bottom and do some things next session. All right, we have got some questions. Don Phillips, didn't the requirement for licensing public adjusting firms get removed from the final bill? Don, that's a good question. I did not think it had. I will check that and get back with you and make sure. Do I need to type the answer too? Okay. Mr. Hargreaves, I have a mediation today. Any last minute things you can encourage me to do or not to do if these things do not go in the way I'm holding clear intentions for them to go to the Merlin law firm? Yes. I believe you're saying you have a mediation with DFS probably. And in my experience, the DFS mediations are pretty useless. So I would tell you to hold firm today. You've probably got documentation showing that you're owed what you owed. Stick firm to that. If they get close to it, maybe think about it. But when they don't get close to it, give us a call here at the Merlin Law Group. We'd be happy to take a look at that for you and help you out. If there are no more questions, I'll give it a minute or so for people to ask questions. Okay, yes, Paul answered it for me. The licensing of public adjusting firms was removed from the final bill. And Paul Handerhan was someone, I want to give him a shout out, and Don Phillips, your president at FAPIA. They were very instrumental in this bill. If they sign paperwork, can they still hire you? It depends on what paperwork they sign. Obviously, if they signed paperwork with another law firm, no, we can't get involved there. We can't talk to anyone who's already represented. But at mediation, if it is, you mean if the case settles? If the case settles, you're likely going to have to sign paperwork that says you agree not to pursue the case in exchange for getting the money. So I doubt that they'll be able to hire someone if they sign settlement paperwork at mediation. I think, okay, you got it? Okay, good. Okay, no problem. So like I said, Paul and Don Phillips were very instrumental in getting this bill across the finish line. And I'm telling you, this bill, I am extremely proud of it because it is going to end a practice that not only I hate, but that I literally saw in some of my cases, and it detrimentally affected my ability to not only settle the case, but get as much money from my client as I wanted. It was so messed up. There was so much unlicensed adjusting activity going on that it really messed up the case. And I had to try to get in and get out the best we could because a lot of bad stuff had happened prior to us getting involved in the case. So I'm proud of this. Rarely can we go to Tallahassee and actually pass a bill that does something to the negative stuff we see in our everyday practice. And we were able to do it with the help of FAPIA, Paul Handerhan, Don Phillips, DFS, the governor's office, and many others. So why did I pick the Merlin Law Group to work for? Oh, that's a good question. Let me tell you, when I was the insurance consumer advocate from 2008 to 2010. I resigned that job to work on Alex Sink's governor's race, if you remember that. And Alex Sink's governor's campaign was based in Tampa. And when that race ended, she didn't win. I was trying to find out what to do, and Chip reached out to me. And I knew that this was the best law firm for plaintiffs' work, and this was the best law firm representing consumers. So I came here. It was really an extension of the work I did as the insurance consumer advocate. And Chip and I also spoke, and he was supportive of me being able to, continue my advocacy. He knew I had an interest in politics, and he is deliciously funny. That's funny, Mr. Hargreaves. But and I love working here. Not only do I love the lawyers here, I love that we're on the cutting edge of not only practicing law, but of this advocacy outside of the courtroom. It's not many law firms that will allow a working attorney. Oh, I'm sorry, Miss Hargreaves. Glennis. I'm sorry. Thought I said Glenn. But I am. There's not many law firms that will allow you to run for office and be as supportive as Chip has. And this is twice. I've run once and was unsuccessful. And the minute I told Chip I wanted to do it again, he was all with it. And so there's not many law firms, not many bosses who will do that. So let me tell you, I consider Chip a mentor. Chip's one of the most important people in my life. And he's a great guy. He's also an extremely, extremely good lawyer. And so he's just a great guy. And like I said, there's not many people as supportive in my life as Chip has been. What will be the status of an apprentice that is in the 8th month of the old rules requiring 12 months? Mr. Bill Cook. It depends. Now, it depends on when the effective date of the bill is, and I forget when the effective date is. I don't know if it's June or July. Let me look into that. Handerhan might have an answer for you right off the bat, but let me look into that because I believe once it is January 2018, so likely they will have completed all of the months bill by the time the bill is effective. But if you're asking that hypothetically, that's a very good question. I'd need to look at the bill closer to figure out if you're in the middle of your apprenticeship, whether the bill allows you to get out of it right then or if you're grandfathered in. That's a good question. is there any interaction with UPL and third-party defect claims? Hold on, I'm looking at your question here, Mike. What's the effect on Supreme Court rules on UPL and the new statute? Seems to imply that we can adjust third-party claims. Thanks for comment. This bill is aimed at the adjustment of claims. The unlicensed practice of law is a little bit different than the unlicensed public adjusting. And let me read this again. Quite frankly, third-party defect claims, I do not know if the bill has an effect on third-party defect claims other than I would assume that you would still have to comply with the adjuster statute. So yeah, I don't know if first-party claims are parsed out or not, or if it's on third-party as well. That's another question that I'm going to get back with you on. These are good. These are very good questions. So third-party defect claims, and Bill, you had a question about whether you'd be grandfathered in under if you were in the middle of your apprenticeship. We will figure that out and get back with you on that. I will look into that. I've been a public adjuster for almost 30 years, licensed in Florida and Texas and Jersey. Every time I see Chip teach, I know he's called to help. He is passionate, kind, and a great all-around guy. Yes, he is. So you've also answered part of your question as to why I came to the Merlin Law Group. It's because of not only Chip, but the other lawyers we have here that really this isn't just a job. This is a passion for helping people. So other than those two follow-up answers that I will get to you, you can also email me at shaw@merlinlawgroup.com or do whatever you think we need to get. Okay, hold on. We got some more. Most policies limit mold remediation to 10K. Need to know if clients need more. Should they seek counsel? Well, if the limit is going to apply, there's not much more you can do. There are ways to get around the limit depending on the facts of the case. So I would agree before you accept the mold limit, I might seek counsel to make sure that that limit applies. Thank you, Christine. Ken, I have been coming across policies requiring appraisers to be impartial. Yes, that is an interesting question. Around the country, there are different definitions of what impartial means. If someone's getting paid a percentage of the award, there are a lot of jurisdictions that suggest that in and of itself means that you're not impartial. You need to, is there anything being done to address this? I guess we could do something around the law dealing with that. I guess we could try to look at that in the law, but I believe that's more of a judicial interpretation of what we believe impartial is, and maybe a definition in the policies of what an impartial appraiser means. There's something I guess we could do in law, but I mean in statute, but I believe that's more of a judicial interpretation question. Oh, let's see. You were saying the limit on mediation here in Florida. I think that other person we're talking about a $10,000 mold limit in the policy, not necessarily in mediation, Glennis. Yeah. All right, guys. Rick, hey, what's up, man? All right, guys. Everyone that's going to come to FAPIA, I will see you at FAPIA, and I had a good time, and we will do this again. One last question. Is there anything in the works to restrict okay, this is the last question, and Bill, here's the question. Is there anything in the works to restrict the problems associated with the unfair practices and the right to repair contracts? Bill, that's something that I am going to look into next session because this is a problem. We all know it's a problem. We all know that they have they enforce these right to repairs, and there's no or very little liability associated with these right to repair. If they do shoddy work, there's not much you can do. Bill, that is something I'm going to look into because that is a problem, and it's a way that they are able to get around doing the right thing where consumers are concerned. And I'm going to talk to DFS about that too. All right, everybody. I'll see you at FAPIA okay. One last question. Hold on. Is there any movement on getting PA fees out of the mortgage company? I'm going to be quite frank and tell you no. We'll try. That's something that we'll work on, but that is a heavy lift considering the banks and the mortgage companies and all these huge interests involved. They just seem to not have an appetite to do that. It's just not to tell you that we're not working on it, not to tell you that I agree with you. I'd like to see it, but that's just going to be a heavy lift and one that we're going to have to keep on working on. All right, everybody. I'll see you at FAPIA. Otherwise, email me any questions and we will keep talking. Thank you. Bye.